Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 189. For those of you who have not yet caught up with it, podcast 188 was with Chris Milsom from Cloisters Chambers. He was talking about how to prepare for and what is involved in conducting remote employment tribunal hearings, something which we're all having to become increasingly familiar with. It's a really good episode, so I would encourage you, if you've not heard it yet, do go back and listen to it. One of the very pleasing consequences for that is that when I posted out the news of the broadcast on Twitter, Chris picked it up and recirculated, and as a result, I've accrued a number of new followers. I'm somewhat concerned to see, however, a professor of employment law at Cambridge University is now amongst them. So I think I'm going to have to do a lot more preparation for these podcasts if they're being scrutinised by such an august audience, and really cut down on the silly jokes and cultural reviews. That's when we get to go back to actually having some culture to review. Anyway, rushing in where angels fear to tread, I'm going to look in this episode at a couple of employment tribunal cases dealing with philosophical belief and discrimination. Then look at a third case dealing with WhatsApp messages, which were used to bring disciplinary proceedings. Although that was in the context of police officers, I think there are some useful pointers, some useful thoughts come out of that for employers generally. Please don't forget, the podcast is available via iTunes, it's on the Mayer Brown website, YouTube, and the Twitter feed Nicholas Robertson at NicholasRober11, which is also where we post out links to the cases we discuss. We're also, of course, on Spotify, Google Play, Yahoo, etc. So, first up, Higgs and Farmers School, and if you're looking that up, that's Farmor School. I think in some ways this tribunal case should be seen as a riposte to a case that I spoke about in an earlier podcast and which I noted generated a fair amount of comment online. And I'm talking, of course, about the Vorstatter case. In the Vorstatter case, if you remember, I expressed some concern that whether you agree or disagree with the beliefs being expressed by the claimant in that case, the employment tribunal in Vorstatter, which ruled against the claimant, seemed to be confusing the issue as to whether or not her beliefs were worthy of respect in a democratic society, with whether or not the way the claimant had manifested her beliefs merited protection for her beliefs. In the Higgs case, what happened was that the individual was employed at a school. She was a pastoral administrator and work experience manager, and one of the things that she was responsible for doing was overseeing the students who had been removed from class for being disruptive. So what she was doing was obviously quite a sensitive role. The school received an email which indicated that Mrs. Higgs had made a posting on Facebook, and the complainant to the school said that the posting indicated homophobic and prejudicial views against the LGBT community by Mrs. Higgs. The article that she had reposted, written by someone else, and she reposted it, as I say, on her Facebook page. Apparently, she had encouraged people to read it, and the article referred to children being brainwashed on the subject of same-sex relationships, same-sex marriage, and whether gender was a matter of choice. Further postings on Facebook by Mrs. Higgs were made available to the school, and as a result there was an investigation, and she was suspended, and then she was dismissed, and her appeal against the dismissal was unsuccessful. As a result, she brought claims on the basis that she'd been discriminated against on the grounds of religion, contrary to Section 13 of the Equality Act 2010. This, of course, provides that a person, A, discriminates against another person, B, if because of a protected characteristic A treats B less favourably than A treats or would treat others. Additionally, the claimant claimed that she'd been unlawfully harassed contrary to Section 26 of the Equality Act. Section 26 states that a person, A, harasses another person, B, if first, A, engages in unwanted conduct relating to a relevant protected characteristic, and, secondly, the conduct has the purpose or effect of violating, abusing the dignity, or creating intimidating or hostile, degrading, offensive environment, etc. 4b. The claimant identified her relevant beliefs in 7 ways, and 2 of these were considered by the tribunal not to be really relevant to the issue, so I won't go into them. 3 of the claimant's beliefs were accepted by the school as having the necessary protection under the Granger case. If you remember, the Nicholson and Granger case says that in order for a belief to attract protection under Section 10 of the Equality Act, that belief must be genuinely held, it must be a belief and not an opinion or viewpoint based on the present state of information available, it must be a belief as to a weighty and substantial aspect of human life and behaviour, it must attain a certain level of cogency and importance, and it must be worthy of respect in a democratic society, and not incompatible with human dignity, and not conflict with the fundamental rights of others. Mrs. Higgs contended that she had a lack of belief in same-sex marriage, which she viewed as contrary to biblical teaching. She has an opposition to sex and or relationship education for primary school children, and she had a belief in marriage as a divinely instituted long-term union between one man and one woman. Now, the school, as I say, did not dispute that these qualified as philosophical beliefs capable of giving rise to protection. We'll come back in a moment to where that led the tribunal. But the point I want to focus on to start with is the school disputed the 4th and 5th beliefs that Mrs. Higgs sought to rely on. Mrs. Higgs contended she had a lack of belief in gender fluidity and a lack of belief that someone could change their biological sex or gender. So the first thing the tribunal had to do was consider whether or not these latter 2 beliefs were protected beliefs. The school accepted these 2 beliefs did meet all the Granger criteria apart from the one that said this belief is worthy of respect in a democratic society, not being incompatible with human dignity and not conflicting with the fundamental rights of others. The school, of course, was relying on the Forstater case and also the case of Macareath and DWP, which is not a case I've talked about in the podcast, but where, similarly to the Forstater case, the tribunal had concluded that a belief, which was very similar to Mrs. Higgs' belief, was not worthy of respect and protection. The Employment Tribunal in the Higgs case had some careful, but I honestly think quite weighty comments to make on whether or not, on the issue of whether or not Mrs. Higgs' belief were worthy of respect or excluded on that ground, i.e. the 5th of the Granger criteria. The tribunal accepted that in the earlier cases it was significant that the claimants, in those 2 earlier cases, would not recognise someone who viewed themselves as gender fluid, and therefore the claimants in those earlier cases might misgender people by refusing to recognise that they believed they were not bound by binary gender. The tribunal in Higgs accepted that if the only way in which you could manifest a particular belief would be by acting unlawfully, then that might lead you to accept that the belief was not worthy of respect in a democratic society. However, if someone was choosing to manifest a belief by acting unlawfully, emphasis on the word choosing, that doesn't necessarily lead you to the same conclusion. So in my words, it's not the belief, but the manifestation of the belief that might be the issue. The tribunal said, quote, "We could see no reason why the belief professed by Mrs. Higgs would lead to unlawful action by her," unquote. The tribunal accepted there was no reason to believe she would behave towards any person in such a way as to deliberately and gratuitously upset or offend them. They then reached the nub of the tribunal's decision on this point. And again, I'm going to quote, "The belief that sex and gender are set at birth may be upsetting to certain people. But if freedom of speech and the rights within Articles 9 and 10 of the Convention only extend to expressions of belief that upset no one, they would be worthless. Essentially, to find as the tribunals did in the cases to which we referred," pausing there, that's Forstater and Macareath, "would amount to a declaration that is open season on people that hold and express the beliefs in question, that they do not deserve protection. That seemed to us to be a strange and somewhat disturbing conclusion," unquote. The tribunal therefore moved to carry out a balancing act between those who held the beliefs in question and those who opposed them to decide whether or not the beliefs are worthy of respect in a democratic society. On the basis of that, the tribunal concluded, very succinctly I should say, that the beliefs in question did satisfy the final test. Therefore, her beliefs in relation to gender fluidity were covered by the Equality Act. So, Mrs. Higgs was over the first hurdle. The next thing which the tribunal had to deal with was the issue of Mrs. Higgs' argument that her postings on Facebook were private. She'd engaged the privacy setting, That meant only her Facebook friends would receive the posts from her. Accordingly, she said, this would be contrary to Article 8 of the Convention, i.e. everyone has a right to respect for private and family life, if she were to be penalised by her employer for what she had posted in a private forum. However, this argument failed. The tribunal pointed out that there were parents of children at the school who were her Facebook friends. The fact that she posted under her maiden name was no sort of disguise whatsoever, because it was very easy for anyone to find out her true identity. Also, people could take screenshots of what she'd said and circulate those comments more widely. The tribunal said that the fact that anyone posting on such a platform, such as Facebook, effectively loses control of their posts, not least when a large number of people can access them. In all the circumstances, we do not consider that she had any real expectation of privacy in relation to matters that she'd chosen to publish in this way, the tribunal said. So, again, a pretty useful comment, particularly for employers who are wishing to take issue with Facebook postings because they feel they may reflect adversely on the employer. This individual had only 100 or so Facebook friends, so we're not talking about an operation to rival Cristiano Ronaldo's Facebook followers. For the record, I've got something like 5 Facebook friends because I'm not really a believer in Facebook, but that's probably by the by. But the point about the Facebook postings is that the tribunal really doesn't have an awful lot of sympathy for postings on Facebook attracting privacy if they're worried about it going out to 100 friends and followers. We'll come back to that because it contrasts somewhat with the last case I'm going to talk about, which has got some comments about WhatsApp. Anyway, having found on that point against Mrs. Higgs, the tribunal then turned to the issue of direct discrimination. As the tribunal put it, they would have to be satisfied that the adverse treatment she was complaining about was because of her beliefs. Here, the tribunal accepted the school could reasonably conclude that someone who had associated herself with the original posting was hostile towards the LGBT community, and trans people in particular. Crucially, the school asserted that if she had merely made her views clear and gone no further than that, they would have taken no action against her. Therefore, the tribunal accepted the disciplinary proceedings taken against her were motivated by concern on the part of the school that by reason of her posts, her actions, she would be perceived as holding unacceptable views in relation to gay and trans people. Interestingly, the tribunal went on to express a degree of sympathy for Mrs. Higgs, pointing out that if this had been an unfair dismissal claim, a reasonable employer, before dismissing her, would have made it clear that if anyone thought she held those offensive views, they'd got the wrong end of the stick, i.e. that the school should be expected to tell pupils and parents that they should not be concerned that she would demonstrate any sort of hostility to gay or trans pupils. However, since this is not an unfair dismissal case, the tribunal did not feel that was relevant. I'll come back to that in a moment. Similarly, the tribunal decided that she was not harassed for her beliefs. Her treatment was not a consequence of her expressing those beliefs in a temperate and rational way. It was because the school felt that the language used in those posts might reasonably lead someone who read them to conclude that she held views which are homophobic and transphobic. On that basis, the basis of her claim, she was unsuccessful. Now, I understand that the case is being appealed, as are the Forstater and Macareith cases, so it'll be interesting to see what the EAT makes of all 3 of them. Now, I put the case into the podcast because I think this is a fault line in society at the moment, and employers are on occasions having to deal with the consequences of this fault line. Clearly, in a society as increasingly polarised as the UK appears to be, strong and strident views are held by many on a number of controversial issues. I personally suspect it would be difficult to find a single issue in which you get 80% of the adults in the UK to agree on in any sort of detail. What's an employer to do when faced with a situation where an individual is espousing unpopular views that are creating offence? Here, in the context of trans rights, which are the forefront of change in terms of societal views, I suspect, you have 2 radically different outcomes. Forstater and Macareith say a view it's not worthy of protection if you have a belief on trans rights that disagrees with gender fluidity or trans rights. I'm simplifying the argument massively, but that's the gist of it. The Higgs case takes a different view. It accepts that individuals are entitled to hold and express in a calm and rational way opposition to gender fluidity. It looks at the manifestation of those views to determine whether or not individuals have been penalised for the manifestation of a view rather than the view itself. To that extent, as I said a moment ago, the school's view that it would not have taken any action against her if she had simply expressed her views in a calm and rational way on Facebook, well, that's critical. Indeed, it makes you want a test case to come along where the individual has not vehemently or not strongly, but calmly and rationally expressed their controversial views. It's probably asking a lot in such a heated area, but a calm and rational explanation of an unpopular viewpoint would be the acid test case. So what do I think the AT will do? Well, in favour of the Vorstatter case, there is a lengthy analysis of the basis for the claimant's views in that case on trans rights, and the tribunal judge comes down fairly heavy in favour of finding the beliefs were erroneous, and then it's a short step from that to saying they're not worthy of respect. The tribunal in the Higgs case goes to no such lengthy analysis. It concludes in short order that the beliefs are worthy of respect, having pointed out the dangers of allowing open season on people who express difficult, controversial views. I think in practical terms, if you're wanting to come up with something that looked like a sort of workable solution, i.e. arguing from the end back to the interpretation, you'd take something along the lines of the Higgs case. You would accept that employers, who are at the forefront of having to manage this, should not be expected to determine whether someone's particular belief is or is not worthy of respect. Employers cannot be expected to make windows into men's souls and then judge them on it. But employers and employees alike are entitled to expect that their colleagues will treat them with respect and politeness, and that cuts both ways. If here Mrs. Higgs had been harassed by a trans activist at work as to her beliefs, to which Mrs. Higgs had responded in a calm and moderate fashion, an employer attempting to resolve that issue, and a tribunal here dealing with any consequent fallout, should take into account surely who was behaving badly, rather than the validity or otherwise of the views of the aggressor. As I say, the Higgs case is apparently going for appeal. I do wonder whether the tribunal's comments about the unfair dismissal case might come back to bite the school. If the school was behaving in what the tribunal clearly believed, although they did not say it in quite these terms, was an unreasonable fashion, that might indicate they were actually more concerned about her beliefs than they let on. I really am very keen to see what the AT will do in these cases. I get the impression that these are the sort of cases that will go all the way up to the Supreme Court. Throw in the added changes involved by Brexit, and really what can happen is anyone's guess. However, speaking personally, an outcome that gives us a little more about our obligation to try to accommodate each other and a little less about my rights to express my views however I see fit might seem like a dose of common sense. So the next case I want to talk about is Mr. S. Jackson and Lidl Great Britain Limited. Sticking with the theme of employment tribunal cases dealing with philosophical beliefs, I think this next case indicates the potential difficulties with trying to establish whether a particular belief system is protected, as well as the surprising twists that philosophical belief cases can bring to an otherwise straightforward matter. The case concerned Mr. Jackson, who was claiming disability discrimination and discrimination connected with his religion or belief. The hearing was mostly a procedural one dealing with applications to strike out or seek deposit orders. However, during it, the tribunal had to determine whether or not the claimant's philosophical belief qualified him potentially for protection. I'm not going to look at anything else other than the tribunal's deliberations on that point. Now, the belief system in question, which the claimant was saying should be recognised as a philosophical belief which qualified for protection under Section 10 of the Equality Act, was Stoicism. Now, naturally, the tribunal worked his way through the Granger and Nicholson guidelines and considered whether or not the belief was genuinely held, was not simply an opinion or viewpoint based on the present state of information available, whether it concerned a weighty and substantial aspect of human life and behaviour, it attained a certain level of cogency and importance, and was worthy of respect in a democratic society, and not incompatible with human dignity, and not in conflict with the fundamental rights of others. Well, the answer's obvious, isn't it? You might think. Well, the claimant gave evidence on his strong interest in philosophy and the particular belief system known as Stoicism. His evidence was that these philosophical beliefs did manifest themselves in his daily life. If he was looking at whether an act which he was to perform was ethical and therefore permissible, the act had to adhere to principles and virtues rather than determining the ethical nature or not of the act in a utilitarian or consequentialist manner. He, in particular, rejected the idea of behaving in a consequentialist manner, i.e., the consequences of what he says or does would not prevent him or stop him from saying or doing a particular thing. A realisation that the consequence of what I say would cause offence would not stop me from saying it, he said. As the tribunal somewhat dryly puts it in response, quote, given that his job is in communications, one could see the potential for conflict, but that is a separate issue, unquote. Anyway, the tribunal accepted he did try to adhere to his stoicism in daily life, and that required him to behave in a particular way. The tribunal accepted. There was no dispute that stoicism as a philosophical belief system had been around for a long time. It was a belief that was genuinely held by the claimant. It was not an opinion or viewpoint based on the present state of information available. Furthermore, the tribunal had little trouble in accepting that it dealt with weighty and substantial aspects of human life and behaviour, and it attained a level of cogency and importance. However, the tribunal hesitated rather more over the final one of the Granger criteria, as they did in the other case I was talking about. Was this belief system, Stoicism, worthy of respect in a democratic society, not incompatible with human dignity, and not in conflict with the fundamental rights of others? The tribunal was concerned that consciously disregarding the consequences of saying or doing something that might or will cause offence could be seen as inconsistent with the values of a democratic society. But the tribunal then went on to confirm that the fact that his actions might cause offence did not, in their view, make the philosophical school of Stoicism unworthy of respect in a democratic society. There was no human right per se not to be offended. Now, the reason I wanted to put this into the podcast was to indicate the potential pitfalls for employers in a not uncommon situation. The claimant was facing disciplinary proceedings. He'd caused offence and apparently, in the employer's eyes, had failed to apologise sufficiently. Here the claimant was suggesting that his stoicism meant he should not be required to behave in a way which was inconsistent with his value system. So what may have looked like a relatively straightforward issue of the claimant compounding an original error, mistake, call it what you will, by refusing to acknowledge it, becomes caught up with the potential for discrimination on the grounds of religious or philosophical belief. Well, in practice, the tribunal struck out a certain amount of the claimant's complaint as having no reasonable prospect of success and made deposit orders in respect of many of the others. So it's not clear how much further this case will actually go, but I think it's a good practical illustration of the sort of problems that can come up for employers and the way in which philosophical belief cases are going to quite easily catch some employers out. In common with the previous case, the fact that many people might disagree strongly with a philosophical belief, or in the case of Stoicism, with what the adherent might feel able to say, was not a reason for denying that the belief system per se was worthy of respect. So, third and final case, BC and others and Chief Constable Police Service of Scotland and others. So this is a case in the inner house of the Court of Session in Scotland, and it was looking at an employer's ability to use private WhatsApp messages exchanged between police officers in the context of disciplinary hearings. I think this is a very real issue. I've lost count, of the number of cases where WhatsApp messages exchanged between individuals have often thrown a decisive light on what was going on in an individual's mind at the relevant time. The problem, I think, is that people have not yet realised that WhatsApp messages are disclosable in litigation if the individual is a party to litigation, or under a DSAR. As such, they express themselves in a way which is often uncharacteristic or a hugely exaggerated version of themselves to make their point. So having the WhatsApps then see the cold light of day can prove extremely damaging. I can think of at least one case in which we were involved where the individual defendant in a restrictive covenant case came across as such an unpleasant character based on his WhatsApp groups, which contained relevant material, that I think the judge was much more sympathetic to our case as a result. Anyway, in this case, the police case, what happened was that there was a police investigation into allegations of sexual offences within the Scottish Police Constabulary. As such, one of the individuals being investigated was found to have sent and received a lot of WhatsApp messages via WhatsApp, obviously on his smartphone. The messages seemed to have been pretty horrendous and were described, without any details being given, as sexist, racist, anti-Semitic, homophobic, and so on. This then led to misconduct charges being brought against him. Now, the relevant police constables were covered by standards of behaviour, and they had to take an oath to act consistently with those standards. This applied to their personal life as well as their working life. For example, the constables were expected to refrain from doing anything that might be seen to interfere with the impartial discharge of the constable's duties. In an attempt to derail the misconduct charges, the claimant asserted that using WhatsApp conversations to bring non-criminal misconduct charges against him was a breach of his Article 8 rights and the right to privacy. The judge in the first instance and the court on appeal rejected this application. However, the appeal court took a slightly different approach to the judge at first instance. The Court of Session said that in deciding whether or not individuals had a reasonable expectation of privacy, pursuant to Article 8, it was appropriate to look at the content of the messages, and in this case, the court could take into account that the police officers had accepted as a condition of becoming police officers, that they would behave both in their professional and private life in a way which did not detract from the impartial discharge of the constable's duties. The point here was that if the individuals were sending sexist or racist WhatsApp messages, that might be seen to affect the impartial discharge of the constable's duties. Therefore, looking at the issue as to whether or not there was a reasonable expectation of privacy, it was legitimate to look at the message and the context of the senders, and in this case, the restrictions that the police constables had accepted. The fact that the recipients of the messages, police officers, were under duty probably to disclose that misconduct because it was falling short of the required standards of behaviour. Finally, the court said that in deciding whether there was a reasonable expectation of privacy, the way in which the material had come into the employer's hands was also relevant. Was it overt and legitimate or covertly obtained? Applying that here, the court took the view that there was a legitimate public interest for discharging police duties impartially, and as such there was a clear basis for the use of material being in accordance with Article 8, i.e. the WhatsApp messages in question didn't have the right. He didn't have a right to prevent their use. They were being used for a limited purpose in the misconduct charges, and they were being disclosed to a limited set of recipients, primarily the regulatory body, or more widely. Interestingly, the judge in the first instance had said that there was an expectation of privacy for people who used WhatsApp, but the Court of Session did not need to reconsider the point because it wasn't something that was challenged on appeal. But the Court of Session did express concerns about this general statement. And as I mentioned earlier when dealing with the first case, it's certainly interesting to contrast the comments about WhatsApp in this case with the lack of privacy apparently associated with Facebook. I think that in this case, whilst it flags up the key issue about WhatsApps, it does leave matters very much up in the air on the use of WhatsApp messages and whether or not they will generally be covered by an expectation of privacy or not. Certainly, if it's possible to argue that if there is professional misconduct in sending, let's say, homophobic or racist WhatsApp chat, then that might well be very relevant in determining whether the employer is allowed to rely on them to discipline the employee. Equally, having been taught that in an employment tribunal context, nice party wins, tribunals may be unsympathetic to attempts to keep embarrassing and relevant material out of sight of the employment tribunal. So, those are the three cases. Range of cases in this podcast, and hope everyone stays safe and well, and we get to another landmark, podcast 190, probably next week. I will look to record that. There's a fair amount going on at the moment, so until then, stay safe, and I'll look to speaking to you again in a week or so's time. Take care all.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.